Hasseltine?
I'm Ty Warren.
Warren. Mr. Warren is here. He currently does not have an attorney
Mr.
appointed.
Warren. Mr. Warren, you want to come on up and, all right. You want to have a seat up here? Or would you rather stay where you
I'll
are?
stay here then.
Okay, that's fine. We can still hear you and communicate well. So we're taking up the case 24 on 130. And Mr. Warren, you've filed this motion to dismiss the state's charge. And I've had a chance we were together, I don't know, a few weeks ago, and we set this hearing. And so I'm going to turn to the state here. I don't have anything filed.
That's correct, Your Honor. And when I was reviewing this late last week, it came to my attention that nowhere in the record did the court authorize the defendant to proceed pro se. And the issue the state has is we haven't provided discovery to the defendant. We haven't provided discovery to counsel for the defendant. And until he's authorized by the court to go pro se, we can't really respond to his motion either.
Well, I think we're at a motion, and this was filed in February. And since April of 2024, it's been clear, Mr. Warren, who's also to us known as Mr. Hasseltine, but Mr. Warren is proceeding representing himself. And he's made it very clear in his pleadings, and I'll allow that. And it's been allowed throughout. So are you going to respond to this motion today?
I can respond orally to the motion, Your Honor. Yes.
Okay.
I do have to express some hesitation and concern here, Your Honor. The state currently has a case coming back from a Superior Court appeal where the court did not go through the pro se properly with the defendant, and therefore the court is overturning that case.
Well, this goes back to a filing of April 2024. I haven't looked through all of the recordings, but I think Mr. Warren, I think it's been clear that you're wanting to represent yourself since this beginning. Is that right?
Yeah, let me make that clear. Without recourse, as my unrebutted affidavit on file in this case stipulate, I am not the ens legius Mr. Hasseltine. I'm not Mr. Warren. I'm a man. My mother called me Ty Warren, and I'm of the Hasseltine family. Sovereign as spoken of in Yickwo versus Hopkins, and not the corporate artificial entity Ty Warren Hasseltine in all capital letters, nor representing the defendant, Ty Warren Hasseltine. I'm not here pro se. I'm here by special visitation, sui juris, in propria persona. You may call me Ty Warren.
Okay.
I'm here under duress and threat of arrest by special visitation, reserving all rights without prejudice under UCC 1-308, and refusing any contract not explicitly agreed to. For the record, I do not consent to the court's general jurisdiction over my person.
All right. So you're in a criminal court and you have the right to be represented by an attorney or to represent yourself, to speak for yourself, put it that way, and not have an attorney represent you. So where are you?
I'm here to present myself as a man,
Okay.
not as a corporate entity.
All right. And I think throughout we've talked about this whole idea about appointing counsel or not, and we haven't done that because you didn't want.
All right, I have to thank Leonard's Unite and Applausible, otherwise known as Zach. Also, you know how it goes. I've got one question for this SovCit.
Ma'am, are you a whore?
Just that.
That. And I remember the times that we've been together. I can't speak for any other judges without looking at their records or listening to their records. So, and the prosecutor's office has been here throughout the times that you've been before the court. And the last hearing, April 8th, was when we cleared up that warrant and we set this hearing. So it's abundantly clear, and that Ty Warren here is speaking for himself or representing himself, and we're going to go forward on that because we've had those discussions for over a year now.
Again, I'm not representing myself or the defendant.
Right, I understand. So I see in the pleadings that you filed that there's at least one. First thing that might be most dispositive is the motion to dismiss based on Court Rule 3.6, which is a suppression of evidence, saying that there was no basis in the law for you to be stopped by the officer. So we're going to start there. Well, I'll make the record here as to jurisdiction and venue. I think I've made that record already, and I don't see anything. I'll hear from the state if there's anything else. And we talked about this at the last hearing, that this is the district court. This is an allegation of a driving offense under RCW 61, also an allegation of obstructing law enforcement. Those are properly filed in this court as they're alleged to have occurred here in Thurston County. And this court has jurisdiction, subject matter, and in personam jurisdiction. So venue is proper as well.
I'm
So
here to challenge that.
I understand. And that's part of your motions. Just making the record that there isn't any basis in your motions that have undercut that reality. So the court does have jurisdiction and venue is proper. So
Based
we're
on
gonna-
what law?
we're going to hit that 3-6 motion. And I'm going to hear from the state as to what evidence they have to present. And I'm looking back to that motion. I think it's about 33 pages. It was filed back in February and reiterated throughout. So Mr. Thompson?
You're speaking of my affidavit.
Yes. And you've filed a lot of information. I've taken it all together. It starts out with that motion to dismiss from going back to, June of 2024. I misspoke.
You can sum it all up with my
Yeah.
most recent affidavit.
Yeah. And that I'm also including in my reading, everything you filed. So now I'm going to jump to the state because they're the ones who have to defend against your motion. I will hear more from you. So, Mr. Thompson?
Thank you, Your Honor. And the sworn statement that our office provided at the initial hearing stands that the defendant was stopped for speeding, and during the course, that was the basis of the stop was speeding.
And so resting on that initial probable cause finding in April.
That was, yes, correct. That was the basis for the initial stop, which would give rise to the Terry stop for an infraction. And from that point on, the defendant refused to give name and gave a world passport ID card or world passport. I don't even know how to fully describe it accurately, other than not a document from a government entity.
So anything you'd like to say more, Mr. Warren or Ty Warren?
Yeah, plenty to say.
As to that issue, let's kind of focus in on issue by issue.
What the prosecutor has just said. He stated that I did not give a name, and then he counteracted himself by saying I did give a world passport ID. And then he said it was not a valid or whatever he said, and not valid or not recognized by the state. But whatever the case, I would like to present what I have to say here. I'm a man visiting here, especially not generally sui juris and deprived persona, solely to challenge jurisdiction.
Let me ask you a quick question. Did you already file the information that you're reading?
No.
No, this is new?
Yes.
Okay. All right. You have an extra copy?
This is just my oral. script
Okay.
that
All
I
right.
Printed out.
Let's see. Try and focus in on the motion to dismiss that you have for suppression of the evidence.
This is what this is all about. It's all about jurisdiction.
Well, we're not
Until
talking
has been
jurisdiction.
Proven on the record, and I have seen no proof of jurisdiction.
Talk to me about your motion to suppress. Talk to me about your allegation
I'm
here.
here to establish jurisdiction or not.
Well, I've already
And
maybe I should be more
there
clear.
are no facts on the record.
I deny your motion as to jurisdiction in this court. So this court has jurisdiction and venue. What I need to hear from you is what do you have to say about your motion to dismiss for a bad stop?
About a motion to dismiss
Okay.
until jurisdiction has been established.
I've denied your motion. This is the correct court. We have jurisdiction, so move on. You can disagree with the court's order, but you can't make it better by just continuing to argue about it. So let's move on to that other motion that potentially is dispositive, the stop.
One moment, please.
Sure.
I respectfully object to that ruling and give notice. I contest the court's assertion of jurisdiction all the way. Let the record show that I timely and persistently challenge jurisdiction, and that challenge remains unanswered by factual evidence.
Anything else? Just looking back through your affidavit and your motion. Anything else for me to consider from you?
Like I said, I have plenty to consider.
Okay. About, first off, as to this motion dismissed based on the bad stop, is what you say.
Yeah.
Anything else? Yeah, I've denied the last one 5 times.
Excuse me?
Your motion to dismiss based on a lack of good reason for the stop. That's what I'm first dealing with.
I can't even address that issue
Okay.
without jurisdiction being established.
Okay. All right. Well, all right, Mr. Ty Warren, Mr. Azeltine, however you want to be referred to. So this is the deal. I'm granting your motion to suppress all evidence
I'm going with Big Dummy as usual.
after a stop. I have no evidence presented that I can consider. This was filed by you in April of 2024. And there's been affidavits and information filed thereafter, all in the court file. We've set this for trial, or we've set this for motion as recently as April 8th. State was present. It's kind of like, for whatever reason, the state decided not to join or prosecute. So under Rule 3.6, I don't have any evidence to overcome what your assertion is that you were peacefully driving down the street. And simply the probable cause statement from the beginning to allow the set of release conditions is not sufficient. There isn't anything in the court file, in the court record, that would allow the state to overcome your motion to dismiss or to motion to suppress evidence. So all evidence obtained, brought forward, is suppressed or not allowed to be brought forward in trial by the state against you. So with that ruling, Mr. Thompson, from the state's point of view.
I believe the court is, well, I have nothing to add, Your Honor. The state will be filing an appeal.
All right, so are you saying that with that order of suppression state, you're thinking an interlocutory appeal and able to go forward?
Yes, Your Honor.
Okay.
Well, I suspect the court intends to dismiss the case at this point. So I don't think an interlocutory appeal is what will happen, but an appeal nonetheless. Again, the state stands by its position that I put into the record regarding his appearance today pro se. I still do not believe that the court has gone through it properly. I will note one additional thing for the record, that in his motion to dismiss, he specifically says that he's doing so under duress, which calls into question the validity of any of his filings. And the reason why the state still believes, even over his objection, counsel should be appointed, because he is not here of his own free volition, as he said more than one occasion in more than one filing.
It's clear to the court he is throughout all of this. The semantics that he likes to use are not persuasive to the court. So, but as I said, the prosecution's decided, not to present. So, as we know, Mr. Azeltine, as we know you as, this matter is dismissed, given that suppression of all the evidence, and you're free to be on your way.
Thank you.
Thank you, sir. Mr. Stashevsky, you got some clients ready to go?
Yes, Your Honor.
Oh, good Lord. This SovCit 1. He has no idea why. I don't know why she suppressed all the evidence. I was busy doing stuff with the stream. What was her basis for suppressing all the evidence? I mean, I don't know. Maybe it was a good ruling. I just don't know why. I just hear that she suppressed all the evidence. Well, yeah, the state can't proceed if all the evidence is suppressed. Based on what? And frankly, I don't think her ruling should count because she doesn't have jurisdiction. I'll have to rewatch it. I'm sorry. I was doing all this stuff for the stream, and I just don't see what her basis for the suppression was. I'm checking the chat. No one's telling me. That's all right. I suppose I should have paid attention. The state failed to file a real response to the bogus motions. That ticked her off. Well, that's insane. There needs to be some basis for it. He didn't argue anything rational. That would be a departure from the norm, and it's the burden of the moving party. He didn't present that motion in any rational way. Oh, good Lord. I mean, it sounds like a horrible ruling, but I wasn't paying attention enough to say. Oh, good Lord. I don't know how it is. I like that judge generally. I think she just... I fear she leaned too much for him here, but it's not a big deal. It is a sovereign citizen. The prosecutor effed up. The prosecutor may have effed up. I don't know that they did or didn't. I can't weigh in on it because I don't know enough. The state's appealing it. Yeah, the state's appealing it. I don't really know how appeals work because with criminal. But I sure as hell, all I heard was this guy just returning to jurisdiction, never arguing a motion to suppress. I find it hard that gets granted without him arguing it. It's possible, I suppose. Maybe there's some strict rule that you have to file a response or the motion's taken as true, but that seems very odd. That seems very, very odd. Well, we shall see. He'll be back. he'll run around and say that he did something. By the way, to the extent that any of that happened, it has nothing to do with sovereign citizen ideology and substance. It's just getting an incredible break outside of that. Despite you're stupid, a judge gave you an incredible break. Is the way I'm seeing this. That's ultimately very frustrating. But I didn't pay close enough attention to really take a position. Yeah, well, that's a good argument. Again, I don't know how it works in Washington, but a lot of places, if you're represented, you can't file motions separately. So why she's entertaining motions? Now, I don't know if it's the case, but if that's the case in Washington, why she's entertaining motions that are filed outside of the rules is odd to me. It's very odd. Whatever. I'll have to watch my own video and figure it out. Thank y'all for coming out. Thanks again, Zach. Thanks, Applausible. Law Nerds Unite. I'll see y'all soon.